So, good morning, everybody, for what is presumably the last time in this very strange semester. This is chapter 36, Insurance, Wills, and Trusts. Um, this is presented chiefly to round out your overall knowledge of basic law and to give you some information that will probably be useful to you later in your lives, if not already. This is probably one of the dopier chapter outlines that we're going to come across in this book. Insurance, wills, trusts, for the chapter called Insurance, Wills, and Trusts. All right, the learning objectives, some of which we have touched upon in the past. What's an insurable interest? When must an insurable interest exist? What are the basic requirements for executing a will? What is the difference between a per stirpes distribution and a per capita distribution of an estate to the grandchildren of the deceased? And what are the four essential elements of a trust? Classifications of insurance. I'm sure you can think of a number of different kinds of policies of insurance. Fire policies, homeowners policies, automobile policies, title insurance. These are just a few of the things that constitute different types of insurance. Life policies, accidental death policies. They're all distinct, and yet they're all related in terms of attempting to present potential compensation against events which are a risk, but which are largely unanticipated, despite the fact that they do occur. Insurance terminology, a policy, that's just simply an insurance contract between the policyholder and the insurance company. A premium in insurance law is the price that is paid by the insured for insurance protection for a specified period of time. In other words, it's the consideration for the contract. An underwriter in insurance law is the insurer or the one assuming a risk in return for the payment of a premium. And generally speaking, recall that just because you got a policy with an insurance company, it doesn't mean that there aren't also other underwriters. So, for instance, Lloyd's of London is famous as being an insurance company, but there are literally thousands of additional underwriters to the Lloyd's of London policies. An insurable interest is an interest that exists when a person benefits from preservation of health or life of the insured or property to be insured. So life insurance, you can have an insurable interest without being the person who is being insured. There was a category of insurance that was typically known as peasant life insurance. Winn-Dixie was infamous for maintaining peasant life policies. What they would do would be to, with the consent, which usually was given at the time that you got hired by Winn-Dixie, and you sit down and you sign 30 different forms, probably basically unaware of the fact that one of the forms you're signing is giving them permission to buy life insurance on your life, with Winn-Dixie being the beneficiary. So that if something happened to, say, a meat cutter, you all remember Alvin Brown, famous executive in residence at Jacksonville University, and one-time mayor, prior to which he was a meat cutter for Winn-Dixie. For example, a meat cutter could come upon something that would lead to his demise, and Winn-Dixie might have a $100,000 life insurance policy on him, and that wouldn't be payable to the meat cutter's family. It'd be payable to Winn-Dixie. And the justification for having that as an insurable interest is that it costs a lot of money to go out and train another meat cutter, for example. In the case of property insurance, you'll recall certainly from the Uniform Commercial Code chapters that one of the things that is important to have if you are going to be purchasing goods in a transaction is to know when you do have an insurable interest, so that at the point at which the goods are identified to the contract and you are able to insure against potential losses, then if something unanticipated does happen, you're not going to necessarily be forced to just engage in litigation over a contract that gets breached because of that, but you may be able to go ahead, collect, and then obtain cover for something that is lost or damaged, since you had an insurable interest and you were able to purchase insurance against known risks. All right, this slide asks a very reasonable question. Why is an insurable interest required for the enforcement of an insurance contract? And quite simply, while it may seem somewhat unethical that Winn-Dixie is able to purchase life insurance policies on its employees and benefit from the tragic death of an employee, does it make sense that any of us would be able to go out and buy a life insurance policy on a stranger? I assure you it doesn't. I mean, this would only lead to potential chaos and events that we're not interested in seeing happen as a society. Like most things that are recognized as being a significant industry in not just America but in the world, insurance contracts have developed a establishment of their own. In order to obtain insurance, first and foremost, there's a requirement of an application. This is largely something that's required by the actuaries who set the rates at which the insurance premiums are going to be charged. Some of you may actually be mildly interested in working in actuarial science. The application, the truthfulness or falsity of the application is going to be critical as to whether or not the insurance contract is later even valid. There will be an effective date for a policy as well as a term. A binder is a written temporary insurance policy, which essentially called that because it binds the insurance company to providing the insurance until the permanent insurance is in place. Co-insurance clauses exist in order to effectively prevent windfall recoveries. If you have a medical policy, for example, there will be a co-insurance clause which will essentially keep you from being able to collect for your expenses from more than one insurer. Incontestability clauses are clauses in a policy for life or health insurance, stating that after the policy has been enforced for a specified length of time, the insurer cannot contest statements made in the policyholder's application. So it's like the doctrine of latches. Basically, the insurance company has to exercise its due diligence in checking out the truthfulness of the statements that are made in the application. The payment of premiums over a period of time is effectively considered to be something that is paid to the insurance company, and if they're not going to bother to check it out, why should they gain by having received the policy premiums when they haven't even bothered to go and check into the truthfulness of the application? Interpretation of insurance contracts. In general, insurance contracts are one of the very few areas where what is a common belief that a contract will always be interpreted against the person who drafted it actually is frequently the truth. It is true that, in fact, courts will very often interpret an insurance contract that is written either ambiguously or in such a way that it appears to bind the insurance company to prevent the insurance company from later turning around and claiming that they didn't mean that in their language, because uniquely the policyholder is unable to negotiate any kind of changes in insurance policy. It is all or nothing from the point of view of the insurance company. Cancellation of policies. There are a number of limitations that are imposed by state laws regarding cancellation of insurance policies. For example, automobile insurance can be canceled for non-payment of premiums or suspension of the insured's driver's license, but they can't just be canceled at the whim of the insurance company. Property insurance can be canceled for non-payment of premiums or other reasons, including insured's fraud or misrepresentation, gross negligence, or conviction for a crime that increases the risk assumed by the insurer. But again, they can't simply be canceled at the whim of the insurer. Life and health policies can be canceled because of false statements made by the insured in the application, but the cancellation must take place before the effective date of an incontestability clause. So if, for example, a life insurance policy contains an incontestability clause stating that after 2 years, the policy will remain in force regardless of the truth or lack thereof of the statements made on the application, then the insurance company has got exactly 2 years in order to turn around and contest the validity of the policy. Duties and obligations of the parties to insurance contracts. Basically, the only duty of the insured is to make sure that they pay their premiums. They obviously had an initial duty to tell the truth on their application, but subsequent to that, as long as they keep the premiums paid, the policy remains in force. The duties of the insurer include, as I said, coverage that's based upon the language as written in the policy. The insurer can't turn around and decide after the fact that a certain provision is being interpreted in a way they don't like if the plain language of that provision says something other than what they claim that it says. What happens is that there can be what are called bad faith actions that are brought by an insured against an insurer when an insurer fails to pay on a policy and the insured believes that the policy should have covered whatever risk the insurer has refused to make a payment for. Bad faith actions under state law will frequently also result in an award of attorney's fees against the insurer, as well as some statutory damages or interest against the insurer as part of the penalty against the insurer for having forced their insured to even bring the action. Defenses against payment include fraud or misrepresentation on the part of the insurer against the insured, lack of an insurable interest, in which case, as we already discussed previously here, the policy is void in the first place, or illegal actions on the part of the insured. And obviously, both in law school and in MBA programs, there are courses that are dedicated solely to insurance law. Wills. What is a will? It's the final declaration of how a person desires to have his or her property disposed of after death. What is being called testate? If your testate it means that you had a will. If you're intestate, then it means that you do not have a will or did not leave a will. The testator, or testatrix, in the case of the Latin female form of that word, is one who makes and executes a will. The executor, or likewise for the female, executrix, is a person that is appointed by the testator or testatrix in a will to administer his or her estate. If you in fact die intestate, then decisions regarding who will be the executor, frequently known as the personal representative, and just exactly how your property is going to pass are going to be made by the state on a statutory basis rather than made by you, the testator, in your will. And again, if you were to go to law school, many hours of at least one and possibly two courses would be dedicated just to wills and trusts. So, what are the types of gifts that are left in a will? There are specific devises which describe the particular property that is being left, and they're general devises which do not describe particular property, but basically leave sums of money without deciding and telling the personal representative where that sum has to come from. After making provision for all of the specific and general devises, sometimes we call devises property that's left that's real estate, and refer to personal property that's being left as a bequest. But it really doesn't matter. You can use them indistinguishably. There is, generally speaking, and there should be, something called a residuary clause. Residuary clause essentially says, after paying for all the expenses, after paying all of my creditors, after paying all these specific and general devises, I have whatever is left, whatever that might happen to be. I want it to be left to whomever or divided in such a way. And the point is that while a residuary clause may initially be intended to only cover a very small portion of the property of an estate, and that's what we call that. Once a decedent has died, the property they leave behind after their death is referred to as their estate. While it may only be intended to cover a very small portion, frequently a residue may wind up covering a lot of unanticipated property that winds up being swept into the estate that the decedent had no idea would wind up being there. So it's important to consider very carefully exactly who's going to be the beneficiary under a residuary clause. Abatement is something that takes place under circumstances where specific property has been left to somebody, but for whatever reason, whether because it's been previously disposed of by giving it to that person or in some other way, the property is no longer available at the time that the will actually becomes active, which is following the death or at the death of the testator. So what are the requirements for a valid will? Every state has slightly different requirements, bear in mind. This is a creature of state law, and they all come initially from the common law of England, so they're all, generally speaking, going to be pretty similar. First and foremost, the testator or testatrix, the will maker, has to have testamentary capacity and intent. Right, so what is testamentary capacity? Does it mean that you have to be completely lucid? Do you have to be somebody that would pass a competency test? Not necessarily. Requirements for having testamentary capacity are quite frequently somewhat lower than what a court would require from a person in order to be able to handle all of their affairs free of having a guardian. But it does mean that you have to know the nature of the act that you're committing in executing a will. You have to know that it is a will, and you have to understand the purpose behind it. It does mean that you have to comprehend and remember the people to whom the testator would naturally leave his or her estate, the so-called natural objects of your bounty. That doesn't mean that you have to leave things to the people that society ordinarily regards as being the folks that you should leave it to. You're certainly free to cut out your specific children, or all of your children for that matter. You're not necessarily free to cut out your spouse, however. And different states have different schemes for that as well, in terms of what they'll allow you to not leave to your spouse. You have to know the nature and extent of your property. So if you own 10 different pieces of real estate, you've got to be aware of the fact that you own 10 different pieces of real estate, and where they are and what they are. And you have to understand what your distribution of assets that you put into your will means. So if you're going to use phrases in a will like per stirpes or per capita, you probably ought to spell that out so that it's clear that the testator actually knew the difference between those two. In fact, if to the extent you can avoid using Latin or any other fancy legal terminology, you probably ought to avoid that. Undue influence is something that definitely can occur in terms of somebody exercising, shall we say, an ethical overbearing upon a testator. One of the most frequent ways in which wills can be contested is because one of the natural objects of the bounty who gets cut out in favor either of another natural object or, say, just a third-party caregiver, who just sort of appeared on the scene in the last year or so of somebody's life. There are frequently going to be accusations along those lines, and sometimes those will be successful in a court, in a probate court, which is what the specialized courts that handle wills and trusts and guardianships are called. You can disinherit, as I say, although you may be limited in the amount that you can disinherit from a spouse. There is absolutely no requirement that a will say, I hereby leave $1 for somebody. There's also no merit, at least in the state of Florida, to trying to say that if somebody contests this will, then they're not going to get the share I'm calling for in the will, and instead will get nothing, because that kind of phrase is actually deemed to be invalid under Florida law. Okay, so assuming you've got a testator who knows enough about his business and the extent of his property and who his kids are, that they have the testamentary capacity and are able to manifest the intent in a will, you still have technical requirements for a valid will. And first and foremost of those, in virtually every jurisdiction, is that a will has to be in writing. There are certain very limited circumstances under which oral wills or non-copulative wills can be legal to a limited extent. Frequently, the limited extent is regarding personal property, and frequently It's only under circumstances like a soldier in battle who would make an oral will to a comrade, and that might be upheld in certain jurisdictions under those circumstances. In general, no, however. So generally speaking, a will has to be in writing, and the writing itself can be informal as long as it complies with the statutory requirements, which means it doesn't have to be typewritten, doesn't have to be printed, it can be in longhand, it can be in block letters, but it can't just be something that is signed at the end by the testator without any witnesses. Every state has a witness requirement, and at least until recently, I'm not sure about now, but at least until recently, some states required 3 signatures. South Carolina required 3 signatures of witnesses, while most states only require 2 signatures of witnesses. An important thing about a will is that the witnesses and the testator have to all be in each other's presence when the will is being executed. You can't have a testator who signs in one room, hands the paper to somebody else and says, go out there in the lobby and get Joey and Mac to witness this, even though that might be their typical practice in their business. You can't do it that way. They all have to be in the same room at the same time, and they all have to sign it in the presence of each other. And again, those folks also have to be at least 18 years old and competent. Now, frequently, in addition to having the 2 witnesses, most folks would rather not have to have a witness tracked down once the testator dies, which is what's going to happen if that's all you did, was just get the witnesses and the testator in the same room and have them all signed at the same time. So most wills will be made what they call self-proving. And in order to do that, you have to also have a 4th person who is a notary public who notarizes the signatures of the testator and of each of the 2 witnesses. Meaning, of course, that 4th person can't be related to any of those 3. If you do that, and there's a special certificate that's attached to the end, then the will is essentially self-authenticating and will get admitted to probate without the need to go track down a witness, which could be something that comes up 30 or 40 years after a will gets executed, and it might present a serious problem otherwise. So you change your mind about something. You want to revoke your will. Well, there are a couple different ways to do it. Probably the easiest way to revoke a will is just go ahead and execute a brand new will, because every will will say at the beginning of the will, I hereby revoke all prior wills and other evidence of testamentary intent. You can also revoke a will by a physical act. You can tear the will up, the original. You can announce to people that I am revoking my will and take some action, whatever it is, whatever you're physically capable of, to intentionally destroy the will. You can not necessarily just revoke it by another will. You can partially revoke it through what's called a codicil. So if you just change your mind about, say, who you want your executor to be, your personal representative, you may go ahead and execute a codicil. Again, the codicil's got to be executed with the same formalities that a regular will has to be. So you'd have to have the testator and 2 witnesses in the same place at the same time. And it may just be that the codicil says, I hereby modify this 1 paragraph so that I no longer want Susie to be my personal representative. I now want Mary to be my personal representative. If it turns out that at the time of a person's death, in Florida at least, that you cannot find the original of the will, even though you could find a photocopy of the will, there is a presumption, what is called a rebuttable presumption in the law, that the testator destroyed the original will and preferred to die with no will whatsoever rather than the will that can no longer be located. When I say it's a rebuttable presumption, it does mean that if you can find somebody who is a competent, qualified witness to come in and say, for instance, well, I know that he didn't tear up his will because he was reading it at the very second that he died, and he died holding it in his hand, and I left the room, and when I came back, it was no longer in his hand, but I did see the window was open and that somebody was running away across the lawn holding some papers. That kind of testimony will rebut the presumption, because then we'll assume that the will was stolen or that something happened to it other than the testator having destroyed it prior to their death. You also have revocation by operation of law. In a lot of states, for a very long time, the fact that you left a spouse property in your will, if you didn't bother to change it upon getting a divorce, then that person was still going to get property under your will. That is no longer the case in most jurisdictions. And marriage does, in fact, do two things. Marriage to somebody who's not mentioned in a will is going to guarantee that they will receive something. Divorce will disinherit the person that was married to you at the time you originally drafted your will. Children, if you have afterborn children who are born subsequent to your execution of a will, they are going to receive the same share that they would have received in the event that you had died intestate. So these are events, marriage, divorce, and having of children, which really should cause people to go out and draft a new will. Okay, a few minutes ago I mentioned something called probate, or probate courts. Probate courts are the institutions that handle probates. Probate is the process of proving and validating a will and settling all the matters pertaining to an estate. And as I noted before, an estate is what we call the property of the person who's died, who is also known as the decedent. There are many types of procedure that get handled in a probate court. First and foremost, there's something called formal probate, which is going to apply to all the states that are above a certain size. And different jurisdictions will define that in different ways. In a formal probate, you definitely have an executor or a personal representative who gets appointed in order to handle the affairs of the estate. In an informal probate, you may or may not have a personal representative who gets appointed. Depends upon the jurisdiction. It may depend upon the size of the estate in that case as well. Probate courts will also handle certain kinds of property transfers that take place outside of the probate process. For example, a designation, at least in this state, a designation that the residence of the decedent was in fact their homestead and therefore is going to pass to a certain set of descendants, totally independent of whatever the decedent wanted to say about it in their will. That takes place by a probate court making that declaration, but in fact is a constitutional process that is taking place outside of probate, even though it's the probate court's order that is determining that the property was in fact homestead, which also means that it was free from creditors' claims and a lot of other incidents of legal whatever to that. Will substitutes, life insurance plans, joint bank accounts can be used as a will substitute. Placing two names with the word or between them on a car title or on a savings bond, or number of different ways that you can take in order to avoid the probate process. Holding property, real property, as tenants by the entireties if you're a married couple, or as a joint tenancy with a right of survivorship if you're not a married couple. They're all ways in which you can avoid property being considered to be probate property. Trusts had been a method for doing that as well, but that has largely been um, eliminated in the state of Florida, at least, because any trust that amounts to being one that holds substantially all of your property, if you're a decedent, is going to be put right through the process, just like a probate estate would have been. All right, intestacy laws. And again, every state has got a slightly different version of their intestacy laws. Um, but in most places, surviving spouse and children will usually receive the remaining assets after the decedent's debts have been settled. In some jurisdictions, the surviving spouse is going to receive all of the decedent's estate, regardless of whether there are any children or not. In most jurisdictions, however, the surviving spouse is going to receive a number, say 50,000, 100,000, whatever that number might be, plus a percentage of the balance of the estate, typically 50%, with the children of the decedent, whether they're minor children or adult children, receiving the remainder, which would be not quite 50% because you're reducing it in the first place by whatever the lump sum is that you're paying to the surviving spouse. If there is no surviving spouse, then intestacy laws in general are going to leave the property to the children of the decedent. If you have a child who is predeceased, but who has in fact also left their own children, that's where we're going to get into the difference between per stirpes and per capita distribution, which we'll do in just a moment. Stepchildren, by and large, are not regarded as being children unless they were adopted, in which case they are considered to be children. All adopted children are considered to be children. And illegitimate children, by and large, are also considered to be children. So if a decedent has no surviving spouse, had 4 children, and 2 of those children have predeceased, one of them left 1 child, and the other left 2 children. If you have what is known as per stirpes distribution, and some states, most states, will call for per stirpes distribution. In the past, some states, in the absence of a designation otherwise, actually would call for per capita distribution. Per stirpes would mean that in the case of this decedent who died, the 2 children that are living would each get 1/4. The 1 grandchild who survived their parent would also get 1/4. And then the 2 children that had survived the 4th child would only receive 1/8 each, because they are taking by per stirpes, by shares. So the share is being divided at the point at which we're determining who's alive and who's dead. In a jurisdiction, and they're unusual now, where, although you could call for per capita distribution in a will if you wanted to, in a jurisdiction that uses per capita distribution, we would count the 2 children and the 3 grandchildren. And then, depending upon how the jurisdiction regards this, ordinarily the 2 children would each receive their 1/4 that they would have received in any event, even if all the children had been alive. But the three grandchildren would each receive 1/6, being a third of the half that would have gone to the two children that had predeceased the decedent. So it's a very different kind of distribution, and it could be remarkably different depending upon the number of children that each one of the deceased children had. And here, illustrating what I just said, is one of the handy charts that typically accompany the chapters of this book. In this case, we see that both of the children of the decedent have predeceased, one having left two children, which would be grandchildren to the decedent, and the other having left one. In percapita distribution, Paul, the child of Jonathan, is going to get half of whatever Michael had, while Holly and Becky are only going to share the half that would have been Scott's, and so we'll each get 1/4. And then in this illustration of per capita distribution, which is probably simpler and easier to follow than the distribution that I explained a couple of slides ago, we see that Michael, Jonathan, and Scott are all gone now. Jonathan and Scott having predeceased Michael. And because we're using per capita distribution, which means that all the members of that class, the grandchild class, are treated equally, they'll each get 1/3, rather than what happened under percapita distribution. Okay, what are trusts? Trusts are unincorporated legal entities. We could call them an arrangement in which the title to property is held by one person, who's known as the trustee, for the benefit of another, who's known as the beneficiary. So typically you will have a trust instrument, and that instrument is going to include a number of facts which you need to have in order to determine the nature of the trust. You have to have a designated beneficiary or beneficiaries. You have to designate who the trustee is, and typically will also designate who the successor trustees will be in the event that that trustee becomes unable to perform their duties. You have to have a fund that is sufficiently identified to enable title to pass to the trustee. And traditionally under trust law, it's been said that the corpus of the trust, which is what we're talking about, can be as small as 2 pins. But it has to be something. And if you have a trust that has absolutely no funding whatsoever, then it's not a valid trust. So even if you just say $10 and actually attach $10, then you have a valid trust. You have to have actual delivery by the grantor, who's the person who's setting up the trust, to the trustee. Because obviously, in the absence of receiving actual delivery of the funds, what's the trustee administering it, and for whose benefit? There are two basic types of express trusts. There are those that are set up during your lifetime and funded during your lifetime. A living, or so-called inter vivos, once again we get the Latin here, trust. A trust is created by the grantor or the settlor and is effective during his or her lifetime. There are two types of living trusts. There are the revocable or revocable living trusts and the irrevocable living trusts. Obviously, if it's revocable, you can revoke it. So you can set it up, and generally speaking, you'll have people that are the grantor also making themselves into the initial trustee, and the trust will at least be revocable by them during their lifetime. And frequently, it will become irrevocable after they die. Or you can go ahead and set it up as an irrevocable living trust in the first place, which means that even if you change your mind, you're stuck with it as the grantor. You can't turn around and take back what you have given. The other main type of trust is a testamentary trust, and that's a trust that's created by a will, so it doesn't take effect until the death of the testator, because, again, it isn't funded, and it's the fact of death that causes the funding of a testamentary trust. And until you have all four elements, including funding of the trust isn't going to be valid. And here we have an example of the type of thing that folks will do. So Mr. Cortez, the grantor, he wants to take his farm and put it into a trust. He is the initial trustee. He also makes himself the income beneficiary of the trust. And if he changes his mind about this trust, he can always go ahead and revoke it anytime up until his death. But then at his death, he goes ahead and he has some kind of remainder beneficiaries who may or may not receive everything all at once, or who may receive income distributions for a while and then later get the rest of it. I mean, it all depends on what he wants to do. And then trusts can be set up for particular purposes. So a charitable trust is one in which the property is held by the trustee to be used for charitable purposes, such as the advancement of health, education, or religion. And a charitable trust can be very specific about exactly who the beneficiaries are. You can literally say this charitable trust is to generate income exclusively for the benefit of Jacksonville University, for example. Spendthrift trusts are special trusts that are created to protect a beneficiary from wasting everything that they would otherwise be entitled to, at least in the perception of the person who sets up the trust. The beneficiary would have been wasting their money. So it may only pay a very small amount to the beneficiary. It may even give the trustee the power to give nothing to the beneficiary if they think the beneficiary has not been doing the right thing. Taunton trusts are trusts that are created when a person deposits funds into their own name for a specific beneficiary who is going to receive the trust on the depositor's death. Basically, it's just a POD designation on a bank account. And then there are at least a couple of kinds of trusts that aren't true trusts, but which are equitable devices that courts use in order to be fair. Constructive trust is an equitable trust that is imposed in the interest of fairness and justice when someone wrongfully holds legal title to property. So if you have a circumstance under which a person has been cheated by anyone, that person or their successors in interest can have a constructive trust that's imposed upon the property that was defrauded from the victim, which is then considered to be held in a constructive trust for the benefit of the person that it was wrongfully taken from. Resulting trusts are implied trusts that arise when one party holds a legal title to another's property only for that other's benefit. So, in other words, somebody has designated a person as their straw man and placed legal title into their straw man's name. If the straw man then doesn't turn it over when they're supposed to, then a court can come in and say there's a resulting trust, which means that the beneficiary can now get title to it as determined by the court. Okay, so what is a trustee supposed to do? Even a trustee who is the same person as the grantor and is holding the property for the benefit of a beneficiary who is also the grantor. That trustee has to maintain clear and accurate accounts of the trust administration. furnish complete and correct information to the beneficiary, keep trust assets separate from his or her own assets. And one of the things that grantors frequently will do that is not correct is to set up a trust and then to not separate the trust assets from their own personal assets. So in effect, somebody could come along later and say, it wasn't a true trust. Trustee also has to pay to an income beneficiary the net income of the trust assets at reasonable intervals, if they are an income beneficiary. Limit the risk of loss from investments by reasonable diversification and dispose of assets that do not represent prudent investments. Basically, they have fiduciary duties to the beneficiary. Their powers are dictated by local law, state law, and tend to be extremely broad, more so in some states than others. Allocations between principal and income are important, and there is an entire subgenre of trust law dedicated to figuring out what represents a growth of principal as versus what represents income from principal, and the circumstances under which, if any, income can turn into additional principal. Okay, typically a trust specifies a termination date, although it may not specify it as a date. It may specify it as being the happening of certain events. Says if no date is specified, it terminates when the purpose has been met. It used to be that there was a limitation called the rule against perpetuities to prevent a trust from lasting, generally speaking, more than the length of a life in being plus 21 years plus 9 months to represent a gestation period. It was a very complicated rule in its application. And the essence of it was that most states now have done away with the rule against perpetuities expressed that way, and instead have established hard and fast guidelines. So a state may say no trust is valid unless it has to terminate within 300 years. And so you simply, if that's a statutory requirement for the state where you're setting up your trust, you just make reference to whatever that provision is and say, under any circumstances, this trust will terminate no later than blank, whatever that date is. Which is why trusts now typically specify a termination date, rather than listing it as being upon the death of a certain life and being. And I guess that pretty much does it, everybody, for, I don't know of any reason why I would be posting any more lectures. I certainly wish everybody, especially graduating seniors, the best of luck in a new and changed world. I don't know what's going to happen if you're going out into the market with a 30 or 40% unemployment rate. It's hard to say. But, keep on trucking.